Namaste and welcome back to our channel Indian Law Analyst. Today we were diving into two fundamental articles of the Indian Constitution, Article 12 and Article 13. These articles play a crucial role in protecting our fundamental rights, so let's break them down. So let's come to the table of contents. Article 12, where we explain what is state and what is local authorities and other authorities. Then we will come to a case law, then Article 13, and then to the question of whether the law includes constitutional amendments with a series of case laws. Then we will discuss about 𝗙𝗵𝗵𝗵𝗵 versus State of Kerala, a landmark judgment of Supreme Court of India. So, what is state? In this part of, unless the context otherwise requires, the state includes the government and parliament of India and the government and the legislature of each of the state and all local and other authorities within the territory of India or under the control of the government of India. According to Article 12, the term state includes the government and parliament of India as well as the government and the legislature of the states and all local authorities. This means that any action taken by these entities can be subject to judicial review if it violates fundamental rights. This article provides the definition of the state in India. The definition of state under Article 12 is applicable only for Part 3, what is fundamental right, and Part 4, directive principles of state policy of the Constitution of India. So we will understand what is local authorities and what is other authorities. Local authorities is defined in Section 3(31) of the General Clauses Act. Refers to other authorities like municipalities, district boards, panchayats, different trusts, and mining settlement boards, or etc. Then, in other authorities, Article 12, the expression other authorities is used after mentioning a few of them, such as the government, Parliament of India, the government and legislature of each of the state, and all local authorities. There is one landmark case related to Article 12, which 𝗦𝗫𝗁𝗃 versus International Airport Authority of India, year 1979. In this case, the Supreme Court ruled that the International Airport Authority was an instrumentality of the state and therefore subject to Article 14, which guarantees the right to equality. Now let's talk about Article 30. This article is all about the validity of laws that are inconsistent with the fundamental rights guaranteed by Part 3 of the Constitution. Article 13 Clause 1 states that all the laws which are made before the Constitution will be void as long as they are violating the provisions of the fundamental rights. It further states that only that the part of the law which will be void which is against the provisions of Constitution and not the whole law itself. Then in Article 13 Clause 2 states that all the laws which are made after the commencement of the Constitution are void to the extent of the infringement of the fundamental rights given in Part 3 of the Constitution. Like that, Article 13 Subclause 3 means law. According to this section, law includes any ordinance, order, bylaw, rules, regulation, notification, custom, or usages. This definition of law is given a wide meaning so that it can be added to a wide variety of state instrumentalities. Let's come to the question of whether law includes constitutional amendments. This question was first decided in the case of 𝗥𝗶𝗵𝗵𝗵 versus Union of India, year 1951. In this case, The Supreme Court held that the word law under Article 13 Subclause 2 doesn't include a constitutional amendment. This entitled that the Parliament has power to amend the fundamental rights according to their will. Later, in the case of 𝗤𝗏𝗪𝗏 versus State of Punjab, in 1967, the Supreme Court overruled the 𝗙𝗂𝗏𝗪𝗏 verdict and stated that the word law in Article 13 Subclause 2 includes the constitutional amendments. If any constitutional amendment is infringing the fundamental rights, then that amendment will be void. To nullify the 𝗤𝗏𝗪𝗏 decision, the Parliament passed the 24th Amendment Act 1971, wherein Parliament added Clause 4 in Article 13, which stated that nothing in Article 13 shall apply to any amendment of this Constitution made under Article 368. Then we comes to know about 𝗙𝗏𝗪𝗏 versus State of Kerala case. The 𝗙𝗏𝗪𝗏 case, officially known as 𝗙𝗏𝗪𝗏 versus State of Kerala 1973, is a landmark decision by Supreme Court of India. 𝗙𝗏𝗪𝗏, the head of a religious mutt in Kerala, challenged the Kerala government's land reform legislation, claiming it violates his fundamental rights and the Constitution. The case was brought to the Supreme Court after several high-profile legal battles concerning the extent of Parliament's power to amend the Constitution. What are the key issues in the case? The issues are whether Parliament has the authority to amend the Constitution, including its fundamental features. And the second one is the definition of what constitutes the basic structure of the Constitution. So, in the judgment, the Supreme Court, in a 6-7 majority verdict, ruled that while Parliament has a wide powers to amend the Constitution, it cannot alter the basic structure. The court identified certain fundamental features that must remain intact, such as supremacy of the Constitution, rule of law, separation of powers, fundamental rights, and federalism. The 𝗙𝗏𝗪𝗏 case is crucial because it sets limits on the amending powers of Parliament, ensuring that certain essential characteristics of the Constitution remain protected. This ruling has since served as a foundation for subsequent judicial decisions regarding constitutional amendments in India. This ruling has since served as a foundation for subsequent judicial decisions regarding the constitutional amendments of India. It establishes the basic structure doctrine, which holds certain fundamental features of the Constitution cannot be altered or destroyed by amendments. So, in conclusion, Article 12 and Article 13 are vital in safeguarding our fundamental rights against any arbitrary actions by the state. They ensure that the power of the state is not absolute and is always subject to the Constitution. If you found this video helpful, please give it a thumb, share with your friends, and subscribe for more insight on the Constitution and your rights. Let us know in the comment what topics you want us to cover next. Thanks for watching Indian Law Analyst. See you in next time. And don't forget to subscribe.